under Article 57 of the Constitution. All the members of the society the owner is now 2:30. Some of us have to eat at 7 intervals. Also, I'm mindful of the court. You have been sitting all the time, you must be now very tired. Let us adjourn to resume that.
Yeah, I think those who are angry can leave. Strong ones.
My Lord, I would like to support the request, very polite request from Dr. Haminwa. Dr. Haminwa is the #1 longest serving member at the bar. And yours truly is #2. So my Lord, breaking for an hour or so is a very appropriate thing to do, and I ask the court.
We want to break by some order.
Yes.
We want to complete the applicant's case. Then we can break.
We will persevere.
You are the last one.
Yes, my lord.
How much time do you want?
I need 5 minutes, but I would appreciate it if you don't knock, because I have dyslexia, so it will make me start rapping instead of delivering
So
my
you take your 5
submissions.
minutes, please.
Yes, my lord.
Your name?
My name is Wanjiro Mwangi. I am the 12th petitioner in consolidated file E65 of 2024, and together with the 11th co-petitioner, Dr. Eboso, we asked to be enjoined as interested parties in this matter. My lord, unlike most people in this room, I want to disclose that I have a learning disability or ability called dyslexia, so I ask for time, not to rush me, so I can articulate myself properly. My lords and my lady, I would like to ask this court to deem myself and Dr. Eboso being properly on record, for the sole reason that in other courtrooms we have made submissions and been told that we are not properly on record, and would like our submissions to remain on the record. My lords and my lady, I only have 5 questions today that I want to task to the judiciary and to the members and to the public and to everybody else. Question number 1, the judiciary on trial. My lords and my lady, the only questions you're on trial for in the eyes of the public is a simple one. Is the judiciary truly impervious to the reach of the corrupt and the political class locally and internationally? If the answer is yes, the Bill of Rights must be respected and upheld. For this, I rely on Article 159(2). Justice shall be done to all, irrespective of status. Read together with Article 27(2), which states, equality includes the full and equal enjoyment of all rights and fundamental freedoms. Question number 2. The Constitution on trial. My lords and my lady, the second question the public will be asking is when our Constitution is on trial, because it is no doubt on trial, will the judiciary bend to the insurmountable political pressure, or will jurisprudence, the Constitution, and the rule of law prevail in such adversity? If the answer is yes, then the conservative orders must be stayed. For this, I rely on Article 27. Every person is equal before the law and has the right to equal protection and equal benefits of the law. Question number 3, the laws on trial. My lords and my lady, the third question that is important to the public is that once a court clearly states that a right is absolute, as this court did on the 23rd of October 2024, then the public will be interested to see and know if the court will uphold its own directions. If the answer is yes, then this court must respect and uphold its own directives and guarantee all the petitioners, especially those who prayed for conservative or injunctive orders whose applications have not been heard and determined, including us laymen, the right to a fair trial as specified in Article 50, which reads, every person has a right to have any dispute that can be resolved by the application of a law decided in a fair and public hearing before a court. Read together with Article 27(3), women and men have the right to equal treatment, including the rights to equal opportunities in political, economic, and cultural spheres. Question number 4, immunity of the office of the president is on trial. The inadvertent question we as a society have to ask ourselves is a moral one. Does the court have any real authority to successfully reverse the impeachment and reinstate Rigathi Gachagua? Based on the truth we know, the truths we have been shown, and the truths we are constantly reminded of by the political pandemic we have been suffering, what confidence does the public have that if the conservation orders are lifted, the court will have any real authority to successfully reverse those orders? Then, under the same assumption, the ascension of Professor Kindiki will succeed after that in a manner of what we expect to be ours, despite the numerous legal ambiguous questions, ambiguous queries about gazette notices in the middle of the night and a lack of IBC commissioners to vet or validate the public participation in that manner. The answer is no. The court will be unenforceable, will be unable to enforce on the office of the president as enshrined in the Constitution and affirmed by the Supreme Court. The court does not have jurisdiction to force Kindiki, if he's sworn in, to recuse him, to impeach himself. That is the real conundrum in a nutshell, and is as simple as the deputy president assumes office, and if the president is unwell, does the judiciary in fact find the impeachment and end if the, sorry. Let me just say it again, please. The real conundrum in a nutshell is as simple as this. If the deputy president assumes office and then the president is unwell and the judiciary does in fact find the impeachment process was flawed from the National Assembly due to violations of the Constitution, what then? Will the acting president impeach himself as a deputy president? Can he even, is it even possible, and who would enforce those orders? The conservation orders cannot be lifted if they will be rendered a nullity, null and void. For this, I submit Article 27. The state shall not discriminate directly or indirectly against any person on any ground, including race, sex, pregnancy, marital status, health status, ethnic or social origin, color, age, disability, region, conscience, belief, culture, address, language, or birth. Question number 5, and my final question today, is our system is on trial. My lords and my lady, on this final note of mine, I humbly stand before you as a layperson with arguably what I hope to be some of the best legal minds in this country. As our nation is once again at the precipice of a revolution, as the spirit of our nation is reawakening, I submit to you one of the most progressive documents in the modern world, our Constitution, a document which guarantees even terrorists due process, whose preamble starts with, "We, the people of Kenya," and ends with, "Adopt, enact, and give this Constitution to ourselves and to future generations." It is time to take our place. It is time for the Constitution to prevail. It is time to no longer allow political urgency to override judicial processes. Our country will still be intact in 30 days, and it will still be intact in 60 days without a deputy president. Our Constitution went so far to envision not only the vacancy of the deputy president, it planned for the eventuality of both the president's office and the deputy's office being vacant. Kenya will be fine. We, the people, will be fine. Let the natural course of justice prevail. It is what we envisioned, and it is what we envisioned for an independent judiciary. Thank you, my lords and my lady. I submit.
Thank you.
It is now 2:30. We will adjourn. I want the assurance that we are coming back for the respondent's case.
Yes.
Your Lordship, that's not correct. My name is Moraro Moke, Counsel. I'm the 43rd petitioner. I'm the 43rd petitioner, and I understand from your direction on Friday that you would hear all applications for conservatory orders. I would like to be guided on that issue.
Which one is your application?
My application is to be found in the petition E027 of 2024.
My Lord,
File in
that
Eldoret.
petition is not consolidated with this.
Hello?
It is consolidated, Your Lordship. Mr. Wanyama, just hold your horses. The petition was consolidated by an order transmitted to me on Friday by the Deputy Registrar, indicating that the 2 additional petitions had been consolidated. Can you kindly confirm that?
I informed all parties that we continue to receive petitions in this matter. We received petitions as late as yesterday. And by the very nature of those petitions, they seek invariably the same orders and the same prayers. But when a petition comes after we have given directions on other petitions, certainly you would not expect us to go back on the petitions which are not before the court.
Your Lordship, Lordship, if you allow me to read the order that I was given, perhaps it can shed more light.
Yeah.
The order said that petition had been consolidated and I'm required to follow the directions issued on Friday in the in the other petitions. That's what the order states.
My Lord, unless I'm mistaken, we were here to hear applications, two applications in petition, one in petition 522, one in petition 565. Equally, we were here to hear two applications from this side that my Lord directed would be treated as the responses to the applications on the other side. If my colleague's file has been consolidated with these files, it does not necessarily follow that his application also had been scheduled for hearing today. And lastly, my Lord, while I'm on my feet, I know we started by giving directions and the court being fair and allowing the parties to drag on and on, but we are concerned on this side that unless the court is able to fix a stop at some point, the other side is committed to proceeding on and on, as I said, until donkeys grow horns. And
We object to that.
Mr. Omoke, how much time do you want to submit on your application?
Your Lordship, I always speak very briefly. I will take only 5 minutes.
Proceed.
And I'll do it right away.
We will be disadvantaged slightly with Mr. Moka's application because he has filed written submissions that he only served on us late last night and we have not responded to it.
Your Lordship, the submissions I filed, they raise the same cases that we all know about. That's the case of Gachagua Munya, which I believe we are sufficiently aware of. And Your Lordship, as you consult, I would like to add that even...
Please don't disturb us when we consult.
That's okay.
My Lord, to end the agony, we have consulted and we concede to submissions in 5 minutes on points of law.
These are the directions we are giving. Mr. Omoke, your petition, we gave directions that it has been consolidated with the petitions before the court. But the fact of consolidation does not mean that your application will be heard. However, because your application raises the same issues as the application before the court, we will give you 5 minutes to canvass that application. And after that, we will adjourn to come back to consider the respondents' responses. Thank you.
Thank you, Your Lordship. My application...
I have a problem. I represent, I'm holding brief for my Prime Minister Ashford Muluki Mukuku. He represents a political party, I respect his political party, by the name of Maendeleo Democratic Party. And we filed an application, and our understanding was that Mr. Mukoko was to be heard today. I wonder if you could take that into account also. Maendeleo Democratic Party.
Which petition?
Which petition is that?
It was not really a petition, it was a motion application.
In which matter? In which matter?
It was to be enjoined in the
Is it cohort 2 or cohort 1?
E565 of 2024. Maendeleo Democratic Party.
My lord, that's not a party in both cohort 1 and cohort 2.
Maendeleo Democratic Party is not a party in any of the two cohorts. It's not a party in any of the two cohorts.
I see. That's interesting.
Okay, Mr. Amoke.
May I say something again?
But Dr. Kamino, you know you appear in cohort 1 in your own right.
Yes.
Remember that. So if you want to submit in your own right, we will allow you. But for the person you are holding whose brief, you don't appear to see where he
I
is.
think Ashford himself, I don't know.
Just look for him so that he can prosecute his case. But in the meantime, let's have Mr. Omoke.
One final word, my lord. My lord, I like being human, and I like taking care of the interests of the judges when they are sitting. You are human. Why don't we adjourn tomorrow?
Dr. Kaminwa, please.
Being human.
It's okay. We are very human.
All that I'm saying, can we start tomorrow?
Let's have Mr.
My lord, I think the cat is coming now out of the bag.
Mr. Omoke, you have 5 minutes.
What's that now?
All right, Your Lordship, if I may proceed, I would like to indicate that I support the application of the first petitioner, and I also submit in support of my own application, which is dated 9th of October 2024. I wish to rely on the affidavit sworn on the same day, my submissions filed yesterday dated 27th of October, and the list and bundle of authorities. In summary, I would like to state my, Your Lordship and my lady, Your Lordship, Presiding Judge, Your Lordship.
What's the date of your submissions?
27th of October. I confirm that I personally attended the public participation at Kiambu Social Hall on 4th of October. And that, from what I observed on that day, I was convinced that I had a responsibility to come before you under Article 3.1 to defend and protect this Constitution. That there are serious violations which this court must consider, and in line with the Gachagua Munya case, there's public interest at stake. Gachagua Munya. There is an inherent, there's a case that you need to consider here, where we must look at all those issues on public participation. Was there proper public participation, not just on the day when the Parliament was conducting it on 4th of October, but even prior to that, under Article 10, I would call upon this court to issue the conservatory orders so that we can have an opportunity to re-examine Article 10, which for a long time has been seen as though it is something that is aspirational. And I would like to urge the court to consider this to be something that is binding on all persons and all state organs. So such that for the move of the motion in the National Assembly, at the time he was seeking to bring that motion before the National Assembly, he actually was bound by Article 10 to observe all the values contained therein, including public participation, go around the country and speak to the people And I'm here to tell you, my lords and my lady, that the people of this country are angry from what I observed on that day, on 4th of October, and they are sick and tired of how the Constitution is being violated.
Well, as counsel is testifying, maybe he can take to the dock so that we can all have an opportunity to cross-examine him on this testimony that he is.
Yes, in response to Professor's objection, I am a party personally, and I saw an affidavit, and I've made all those averments therein. And if I'm required to be examined, I'm very much happy to do that, if you require that. So perhaps Prof can confirm, and I'll take the doc very happily. All right, so I'll carry on. He has agreed that he wouldn't like to examine me, so I'll continue with my presentation. Actually, at that very same public participation, I did meet some of the people from his famous home, Ndumberi, otherwise known as Danbury, and they were very, very unhappy with the way the process was being conducted. And that's why I've come here, not just to speak for myself, but also for all of these people. I would like to tell you, your lordship and my lady, I'll close my presentation here because I know that we have an opportunity to examine these issues at a later time.
Thank you. These are the directions we're giving. It is now 20 to 3. Is it? Yes. We can take a 45 minutes break. We come back at 4:30.
Half past 3. Half past 3.
3:30. It is now 20 minutes to 3.
That's correct.
So we can come back at 3:30?
Only one thing, Your Lordship, that we still have interested party who might want to support the application. You indicated that you'll be coming for the respondent's case.
There's no problem. You are coming back at 3:10.